Thank you so much, Frankie, for setting that stage, for setting that context. It is not a complicated legal argument, in spite of what will be said in the court today. It is a fundamental issue of fairness. Our next speaker is Lía Fiol-Matta, the Senior Counsel of LatinoJustice PRLDEF and one of the amici in today's hearing. Lía.
Thank you. Buenos dias. Good morning to everybody. LatinoJustice PRLDEF, the Puerto Rican Legal Defense and Education Fund, is a national civil rights organization dedicated to protecting the civil, constitutional, and human rights of Puerto Ricans and the Latino community. We are here today in support of José Luis Vaello-Madero in this case of national importance, which involves the equal protection rights afforded by the Due Process Clause of the Fifth Amendment within Puerto Rico. We, along with partner organizations, oppose the Biden administration's defense of what is, in essence, blatant discriminatory treatment against the residents of Puerto Rico by denying them necessary and often life-saving federal benefits, which they are entitled to as American citizens, and have filed an amicus brief in support of Mr. Vaello-Madero in this case. Under the Social Security Act, Congress grants disability benefits to residents of the 50 states and the District of Columbia, yet deprives Puerto Ricans of those same benefits on the supposed basis that they are, and I quote, outside the United States. The rationales underlying the classification of Puerto Rico as an unincorporated territory under what are known as the insular cases are replete with racial and ethnic animus against Puerto Ricans. We believe the court must apply the highest level of judicial scrutiny to the classification at issue here, because residents of Puerto Rico meet the standards applicable to a suspect class. Excluding them from Social Security disability and other needs-based federal benefits is premised on a classification grounded in racist stereotypes, which are subject to strict scrutiny. The discriminatory treatment of United States citizens residing in Puerto Rico is premised on the insular cases, which were decided by the Supreme Court beginning in 1901, concerning the status of United States territories acquired by the United States in the Spanish-American War, including Puerto Rico. The cases created a distinction between incorporated and unincorporated territories, such as Puerto Rico. The Constitution would apply differently to those unincorporated territories. These cases have been heavily criticized due to their strong racial and ethnic basis and should be overturned by the Supreme Court. Subsequent decisions have applied the insular cases or their reasoning in finding that Puerto Rico may be treated unequally in connection with federal entitlement and benefit programs. While the Supreme Court decided last term in the Aurelius case that it did not need to consider the request of some parties, and I quote, to overrule the much criticized insular cases and their progeny, end quote. The Supreme Court should do so now because the ultimate basis of the government's argument is the disfavored reasoning of the insular cases. The court should follow the precedent set by Trump v. Hawaii when it overruled Korematsu v. United States as being, and I quote, gravely wrong the day it was decided and having no place in law under the Constitution, end quote. That reasoning and conclusion is equally applicable to the insular cases, and the Supreme Court should overrule them and affirm the judgment of the Court of Appeals. Thank you.